first of all say I'm happy to be doing this again. We used to do these meetings a lot during COVID, but then afterwards, less. I'm so happy to have with us this special guest speaker, Yonatan Green, the executive director of the Israel Law and Liberty Forum. I was just talking with him a few minutes ago and saying that I was very impressed with the work he's been doing in explaining the points about the judicial situation and the judicial reform here in Israel, and with other things that I've seen the forum doing. As early as I remember a debate with Ruth Gabizon and Professor Ruth Gabizon and Barak Medina in the fairly early days of this forum, right?
Right, yeah.
Yeah, and I was impressed with it already back then. Johnny is one of the vocal speakers for these matters, and he was a member of the Kohelet. He was, right? You're not, yeah, working.
A long time ago, I used to work for Kohelet as a researcher.
Yeah, the Kohelet, just for you who are not like familiar with this, is a think tank, Israeli think tank that deals with several issues, I would say, leaning towards the free market, classical liberal ideology. Is that kind of accurate, or?
Sure, yeah. Among other things, yeah.
Yeah, among other things. And Johnny is both certified attorney, both here in Israel as well as in New York. So he is an attorney not just by ethnicity, like I am, he is also by profession. And you cannot go more, Jewish attorney than being certified both in Israel and New York, right? So you're probably at the top of your professional identity. You essentialize everything that is legal, essentially. If I'm being a little bit humoristic about it, but if there is anything that I forgot to say about you, Johnny.
Sure, I can fill in if there's anything missing. I'll say a word anyway when we get started.
Okay, sure. So let's get started. Introduce yourself in the parts that I failed, and I'm sorry for all my failures in advance. As far as how we're going to do it, I thought about you can do whatever. I'll accommodate whatever direction you want to take. I thought about what was the situation that called for the reform, what are the basic parts of the reform, and what is the opposition and the idea behind the opposition for the reform, and maybe later on, what are the compromises that are on the table. Maybe that's kind of a direction, but you can take it from here, and I'll try not to intrude too much.
Well, thank you very much, Netanel, for that very nice introduction. And you can feel free to intrude as much as you like. I think should we get rid of the thing that you're sharing of the?
Oh, sure. Yeah, we can get rid of it. And guys, if you want to open your cameras, you're more than welcome. I'll keep the microphones closed, and later on when we have Q&A, we'll open them again.
Excellent. Thank you, Netanel. So yeah, please, Netanel, feel free to interrupt me if there's anything that you think that requires that. And for the participants today, first of all, it's nice to see this sort of interesting and diverse group from all over the world. And it's always kind of a treat. And please do go ahead and write in the chat box if you have questions. That I'm sure we'll get to some of them. I'm sure some of them we won't get to, but we'll do our best. By way of introduction, so I think Netanel covered all the important points. I will also mention that I'm a born and raised Israeli, even though my dad is from the U.S. and my mom is from the U.K. Like Netanel said, I'm certified and licensed to practice law in both in New York and in the state of Israel. Today, I am executive director of the Israel Law and Liberty Forum, which is an Israeli legal nonprofit organization that advances a conservative legal worldview in Israel. However, I do want to make a really, really important point to start off with, is that anything I say here today is representing my own personal views as an attorney, as an Israeli lawyer, as a legal expert, and does not reflect in any way the organization that I run. The Law and Liberty Forum is separate. It's a separate topic, and we're not going to discuss that organization and what it does today. And that's why it's important for me to make that distinction, that here I'm representing my own personal views. So Netanel, you suggested, I think, starting off with a background a little bit, right? Or sort of
Sure. What calls for a reform? Why do you know? Don't fix it if it ain't broken. So let's understand what's broken.
Well, obviously, I mean, I think there's one more preliminary sort of comment that needs to be made here, especially I can see that we have a sort of the audience here today, and I'm assuming also the people that will be viewing this later on, will be viewing the recording. I can see a really diverse group from all over the world. I mean, I'm looking at Namibia and Ontario, South Africa, Zimbabwe, Michigan, Texas, California, Germany, Indiana, California, Trinidad. So really all over the place, which is fantastic. And then this is actually a really important point. Look, we're going to cover something here today in our discussion, but this is a really, really complicated topic. And there is an enormous amount of nuance, of all these different details, of sophistication, that it's really just it's really difficult to get around. And if you are an English speaker and not a Hebrew speaker, and you are not immersed in the Israeli Hebrew speaking conversation, then there are severe limits on how much you can ultimately understand about this. And that's not, of course, you should be interested and curious. You should be, if this is something that interests you, you should be striving to have a sort of rounded and well-formed opinion. But at the same time, I think it's healthy to recognize the inherent limits on how much an outsider, a foreigner who's only speaking English can understand all this, can track and cover all the different nuances and details. There is really, really significant disagreement in Israel between sophisticated, thoughtful, well-meaning people, meaning this is a fundamental and really important issue of disagreement about all of these, about everything. And anytime you're presented with something which seems simplistic or, sort of too sort of straightforward or whatever it is, then you can assume that you're not really getting into the details. And ultimately, I think what this means is that you need, as in anybody in this situation, one needs to reserve judgment and to understand that as an outsider looking in, you're getting a very partial view or these sort of small vignettes into the situation in Israel. And the one last thing I'll add about that is that, and this is another thing we need to recognize, the global milieu in Israel, the global English-speaking, outward-looking group is clearly, or for the most part, aligned with one part of this disagreement, with one part of this conversation. So if we're talking about the main parts of the media, the mainstream media, the main parts of the academia, they are very clearly on one side of this. And they are the main group which is discussing the judicial reform and everything around it. They're the main group that's communicating everything outwards in English to other countries. And this means that you're getting an even more so a sort of skewed, I'm not going to say one-sided, but certainly not getting the sort of full richness and complexity of the situation. This is not to complain against these people. They're doing their jobs and they're communicating the ideas as they understand them. But this is to recognize the reality. The global English-speaking, outward-facing elite in Israel is certainly aligned with one side of this conversation. That's something we need to recognize. So sorry, after that very long sort of caveat or sort of introductory remark, the background. The background is really hard to explain because there's a lot going on, but I'll try and sort of summarize it in some very sort of in some very sort of quick key points. And of course, this will be in broad strokes. I mean, this is these are generalizations. Over the past 30, and some might even say 40 years, over the past 30 or 40 years, the Israeli Supreme Court, the courts more generally, but certainly is most especially led by the Israeli Supreme Court, has arrogated to itself, has seized for itself an enormous amount of power that many people in Israel see as illegitimate, as without basis in law, without basis in democratic practice, without basis in democratic custom. There's a lot of detail, and we can give sort of a few key examples. But that is a general gist in the sense that the Israeli court has given itself, meaning this is not powers that were granted to it. That would be a different conversation. But the Israeli court has seized for itself powers which are really incomparable to any other democracy, to any other Western liberal country in the world. And I think that's sort of the real sort of crux of the issue. It started from the early 1980s when Justice Aaron Barak joined the Supreme Court. Some might, it's a little hard to date exactly when. One major milestone of this was the reasonableness revolution, which we can discuss a little bit in Israeli administrative law and Israeli sort of judicial review of ordinary administrative governmental action. And then it progressed slowly into other areas, eventually culminating in, or not even culminating, but eventually hitting what some people call the constitutional revolution, where the court decided, some people say unilaterally, where the court decided that it had the power to strike down legislation, and it decided that Israel had a constitution, even though many people disagreed with that. And I think to this day, that point itself is in contention. And Israel, many would argue, does not have a constitution. We can dive into all these, but this is just to give you a sort of a broad idea. So the 80s and 90s especially, but also since then, have seen some really fundamental, dramatic shifts created by the Israeli Supreme Court. And I have to say, these are regime changing shifts. These are fundamental shifts in the entire Israeli political system. The most severe one, or the most obvious one, I guess, is the constitutional revolution, where the court decided that Israel had some kind of constitution, the Israeli quasi-constitution based on the basic laws, and that constitution granted the court the power to strike down legislation. But there are other factors as well. Other factors include the way the court has barred judicial candidates from joining the court because of the court's power, veto power over judicial appointments, and the court has abused that power to bar
Johnny,
yeah.
Let's go with
I know this is very broad.
Yeah, I know it's, but let's give some examples as to how judicial review has developed in Israel based on a non-existing or not yet existing constitution.
So until the 1990s, the consensus on the court and throughout the Israeli legal community was that Israel was a parliamentary democracy without a constitution. And that means, just like every parliamentary democracy without a constitution, that the court cannot strike down laws. This is a very fundamental rule, a fundamental idea. The idea is the people that make the laws is the legislature. And the only way in which you could justify a court saying a law itself, a law duly enacted by the parliament, is illegal, is when it can do so based on an actual constitution. And seeing as Israel never enacted a constitution, which everybody agreed that was the case, then of course the court didn't have that authority. And this was reviewed time and again on many occasions by the court throughout the years. And this was the case until the mid-90s. There were many examples of different petitions that tried to strike down laws. There are a few tiny exceptions that I'm not going to get into, but these were based on technicalities. So if you had a law that didn't pass with the required amount of votes, for example, so the court might say that they won't enforce that law. But that's sort of a procedural technical flaw, not the kind of flaw that we talk about when we talk about striking down laws as unconstitutional. Then in 1992, the Knesset passed two important basic laws that dealt with fundamental rights, with human rights.
Just a second, what is a basic law?
Right, yeah, absolutely. Well, I mean, we're really getting to the constitutional history here, and then again, it's sort of a lot of ground to cover. But
so in one sentence, as you know, if I understand correctly, because I'm a layman, so I'll ask, and essentially constitutions are made of two parts. One of them is the way the government works, the different branches of government and the relationship between them. And the other part is what is equivalent to the American Bill of Rights, right? So essentially basic laws were supposed to be the future draft of a future constitution. And after having been completed, they should have been verified or kind of consolidated. Come again?
Ratified
and consolidated into a future constitution. And these are the basic laws. When up until the 92, all of the preceding basic laws dealt with a part of how the government works. And in 1992, for the first time, two of the type of Bill of Rights, constitutional or basic laws, were introduced. Is that like a fair?
It's close enough. I do have to say, even that needs to be qualified. And I'll say, but I think you definitely give the correct gist. I'll just say that yes, at the founding of the state of Israel, Israel never got around to forming a constitution, which they thought and hoped that they would. And what was agreed by the Knesset, this wasn't sort of even legislated. This was just kind of a vote that, you know, people agreed in the Knesset and had one vote on.
Right, the Harari Compromise.
The Harari decision, the Harari Compromise, that said, you know what, we're not making a constitution. Let's legislate something called basic laws, which are just ordinary laws. There's nothing special about a basic law, except that it has just the title basic law. And all that meant at the time, making a basic law, all that meant was that this was sort of marked as a potential section of a future constitution. That was the meaning of saying basic law at the title. And this is important because there were many very, very important laws which didn't have that title of basic law, which are unquestionably part of Israel's constitutional framework. And the most obvious example is the law of return, which is one of the most important laws in Israel, part of Israel's Jewish character and identity, and part of, you know, a core rule of Israel's repatriation. But we're getting off topic. Throughout the years, Israel did legislate a whole bunch of basic laws. The place that I'm going to qualify what you said, Netanel, is that throughout the years, the Knesset did legislate all kinds of laws that have to do with rights. They had laws that had to do with sort of gender equality rights and women's rights. They had non-discrimination laws that the Knesset passed. They had worker and employee rights, and of course, you know, the right of rights. They had the right to vote and the right to be elected. That's also a right that was enshrined in a basic law many years before. So, I mean, even I think the argument that this is some kind of momentous occasion. Yes, this was the first time that Israel sort of tried to legislate a kind of comprehensive or sort of a proper, something approaching a Bill of Rights. And yet, you know, the Knesset had legislated rights many times before this as well.
Mm-hmm.
But in 1992, this was some kind of landmark piece of legislation. At least that's how some people viewed it. But again, still within that framework, still within the framework of basic laws are merely drafts of future chapters of the Israeli Constitution. And the giant leap that happened next is that in 1995, in a famous court case called Hamizrahi, the Israeli Supreme Court decided that these two laws were sufficient to be viewed as part of the Israeli Constitution, and that for all intents and purposes, or at least for the purpose of striking down legislation, Israel now had a constitution. And this was what Aaron Barak himself, who was the Chief Justice of the Israeli Supreme Court at the time, or he was becoming the Chief Justice at the time, he himself called this the constitutional revolution. And the argument was that the passing of these two basic laws were now sort of a major milestone, a major turning point in the Israeli Constitution. And now all the basic laws could be seen as a constitution, and ordinary laws could be struck down as illegal or invalid or unconstitutional if they contradicted what happened in the basic laws, if they contradicted what it says in the basic laws, and especially the new ones that were passed in 1992. Now, there's a huge amount to say about this. Again, we can dive into the details a little bit, but I want to sort of give the basic critique here. This is, at least in many senses, this is part of the original sin of the Israeli legal system. This is the rot at the core of our system, because really there are three systems. There are three types we'll call it three types of judicial review of legislation in the world, three models throughout the world. Okay. There's one model where there's no judicial review of legislation, and that's like the UK, New Zealand, Holland, Luxembourg, Switzerland. So there are quite a few countries in which the court, democratic, liberal, Western countries, in which the court cannot invalidate legislation. The second model is countries where you can invalidate legislation. A court can struck down legislation based on a constitution. And when I say a constitution, I mean what we all think of when we say constitution: a proper constitution, which is this comprehensive, integral document, which is passed in a specific process, which shows a sort of deliberate, conscious effort by a broad consensus to enshrine specific ideas and rules about that particular regime. So that's what we usually mean when we say constitution. And that's the model in the world when we talk about striking down laws. The third model consists only of Israel. And Israel struck out this unique and novel model, and I'm saying that really not as a compliment. This is the anomaly of Israel, where the Israeli court decided that the Supreme Court can strike down legislation without any constitution to speak of. So the so-called Israeli quasi-constitution isn't remotely close to anything that we usually think of as a constitution throughout the world, and doesn't meet the criteria that we usually think of legitimating or allowing a court to strike down primary legislation. This
is what they call a living constitution, right?
Close enough, even though I would say it's much worse than a living constitution. It's kind of a ghost constitution, because a living constitution is the idea, among other things, in the American US Supreme Court and elsewhere, that there's a constitution, but we can interpret it according to the current times. That's the idea of the living constitution. That is not what happened in Israel. In Israel, you have the resurrected. I don't even know what to call it.
Listen, resurrection happened in Israel. You know,
constitution. It's taking a dead body. It's like taking a doll and saying this is a live constitution. And just to clarify, this was a quantum sort of leap. This was a massive, through a sort of feat of legal and logical acrobatics, the court sort of went all around itself just to say that Israel has a constitution. And one way to demonstrate this is two things. The court case itself, HaMizrahi, is 600 pages long. And the vast majority, some people try and compare HaMizrahi with Marbury versus Madison, which is a famous US court case, which said in some way or other that the US Supreme Court has the ability to strike down laws. Primary legislation is invalid if it's inconsistent with the Constitution. From
the late 700s, right? The 1700s.
I think it's the early 1800s, but yes, it's and some people make that comparison, including our own Barak himself in HaMizrahi case, and that's completely unfounded, because in Marbury versus Madison and elsewhere, there is no question about the existence of a constitution. That is not what's being debated. And in the HaMizrahi case, the vast majority of the disagreement, of the deliberation, of the explanations in the ruling itself are to convince the reader that Israel actually has a constitution. And this sort of belies the fact, this kind of exposes the fact that, of course, if there's a question, if there's disagreement about the very existence of a constitution, that ought to resolve the question itself. Meaning, if there's any question about the existence of a constitution, then there really is no constitution. The existence of a constitution is not something which is supposed to be under disagreement at all. It's not something which you're supposed to convince the other side. So this is all very, very broad, and I think again, it's easier to sort of get lost in the details. But this is why I'm deliberately trying to give you the big picture. This is the fundamental flaw where the court did something which no other country in the world does, where it said, even though we don't have a constitution in any accepted or established way, we're going to go ahead and pretend that we do, and the justifications, be what they are. And I think they're unconvincing, but whatever the conversations are, let's pretend that we do have a constitution, and then based on this pretense, let's strike down laws and do many other things, which this constitution tries to protect. Now, there's a lot more to say about this. This is only one part of the flaws, I think, which judicial reform in Israel is trying to fix. I mean, I don't think we should limit the understanding only to the constitutional question. Like I said, there's the reasonableness doctrine, there's the powers of the attorney general, which is something that needs to be discussed. There's the way judges are nominated or appointed in Israel, which is highly problematic and unusual from a democratic perspective. There are many other fundamental sort of systemic flaws in the Israeli legal system, but these are just a taste or sort of a smattering of some of these problems.
Yes, but it's some of these core issues that you've just mentioned are intertwined in the sense that, and the backbone of it might be what you said, in the sense that the court is backing up, for instance, reasonableness is a question of how, which is only relevant if they have the authority to strike laws, So what is the basis,
Right.
if they don't, yeah. So
Well,
they're
I think it's actually, I think it's very tempting, and some people try and do this, to say, here is the one core problem, and everything else stems from this, or here is the fundamental problem, and this is, this is it. And in Israel, I'm saying, unfortunately, that's not the case. Each of these, there are a handful of problems, each of them of equal severity, or at least similar severity, and each of them stand on their own. Of course, there's a great deal of interplay between them, and they affect each other. We started talking about reasonableness. Reasonableness is this novel Israeli doctrine where the court can strike down not laws. So here we're not talking about striking down laws. We're talking about the decision of the government, any sort of action or decision or policy of the government itself, including sort of inherently political decisions or policies. And the reasonableness doctrine developed by the Israeli court says that the court can strike down these, or sort of, can invalidate these governmental decisions based only on whether the court thinks they were reasonable, not based on them being illegal, not based on any of the sort of accepted or established or sort of known.
Right. Not just arbitrary and capricious as it would be in America.
Exactly, as you would have. So not based on any of the sort of standard grounds for review. And we can, again, I'd be happy to go into that a little bit if you'd like me to. And this is in itself its own problem, meaning if we never had the constitutional revolution, and if the court never invented the Israeli constitution and didn't invent for itself the powers to strike down legislation, we would still have a severe problem with the reasonableness doctrine, meaning that's its own problem.
Right, because that's related to the administrative law, not to the constitutional law.
Exactly.
Okay.
When we talk about striking down legislation, we're only talking about, invalidating laws that were passed by the Knesset, by the Israeli parliament. However, the reasonableness doctrine deals with something else entirely. It deals with governmental action, which is not legislation, could be the decision of a minister, could be decision to appoint somebody, could be some particular policy which is being enacted, etc. So
could be the decision on which day to take out your garbage.
Correct. It could be the decision of what day your garbage is collected in your neighborhood. And again, we could go into this, but this is just one example of how the court has.
Okay, so just a second, Johnny. So far, we've talked about theoretical constitutional law, and I think that maybe some people have the cameras off because they fell asleep by now. But how about
let's go into the real world for a second.
To the key examples of how does this affect our lives?
So let's talk about both of these examples, both reasonableness and striking down legislation. Let's talk about striking down laws. The court, since 1995, the court has struck down something like 22 laws. And I'll give a handful of examples. Two laws that were struck down have to do with the exemption, the military exemption, or the military draft exemption for Haredis, for ultra-Orthodox people from the Israeli military. So generally most people at the age of 18, most men in Israel are drafted to the Israeli army for mandatory military service. And throughout the years, the Haredi, the ultra-Orthodox community, were exempt. This was sort of part of the understandings at the founding of Israel. And we could, the question of whether this is a good or bad policy is a separate question, which we could debate or discuss for a very long time. I served in the military. I still serve in the military. And this is sort of a separate question. What happened was that the court gradually, but of course, starting in the mid-1980s, first of all, using the reasonableness doctrine, among other things, ruled that this policy could not, needed legislation. They essentially said that this policy needed a specific legislation. It wasn't enough that the law allowed the Minister of Defense to grant this exemption, but rather that you needed a specific law that said that ultra-Orthodox men are exempt from serving in the army. So the Knesset went ahead and made a law that does precisely this. Now, again, this is one of the issues which is at the heart of Israeli public debate. This is one of the most contentious issues in Israeli society today, and for the past 20 years. So the Israeli parliament reached a historic compromise about this exact issue, and they enacted legislation as a parliament does, and they explicitly granted this exemption for military service for ultra-Orthodox men. Now, again, forget it for a moment if you agree or disagree with this policy. That's a separate issue. You have to have that separation in your mind between whether you think this is a good or bad idea. That's a different conversation. This is the compromise that was reached by the Knesset, by the parliament. And I just want to remind you, this was granting a benefit to a minority, meaning this is not some kind of law that hurts a minority. This is not some kind of law that discriminates against a minority. This is a law that benefits a minority. This is a law that has nothing to do, it wasn't harming any rights. It wasn't harming any minorities. The opposite. It was granting sort of extra benefits and rights to a minority. And the court struck it down, not as unconstitutional. Not only did the court strike down this law, it actually did so twice, meaning they tried re-legislating a different law, an amended law, which they hoped that the court would allow, and the court struck it down again. And not only did the court struck it down, but I want you to follow because it's a little bit complicated. In the basic law of human dignity and liberty, there is the right to dignity, okay? But this basic law does not include a right to equality, okay? The basic law that was eventually legislated deliberately did not include any right to equality. This was part of the compromise in 1992 that allowed this law to be passed. Previous drafts of the law, the basic law of human dignity and liberty, had a right to equality, and this was eventually removed from that law. And this
Just
was
a second, Johnny. Maybe here I should ask, or like the Seder is coming, and we have here the children should ask. So what's so bad about equality? Isn't equality so good? You know why?
So, yeah, I'd be glad to get into that, and I will in just a moment. But I want to stay focused just for a second, so we don't lose track of the issue.
We'll keep that in mind. I'll keep the question. I'll ask it later.
I want to keep track for a moment of the I want to keep in mind for a moment this discussion of the ultra-Orthodox men. So the court interpreted the right to dignity as if it includes equality. So I want you to understand what happened here. The right to equality was deliberately and explicitly not included in that law. The court, fully knowing this, said, you know what? I'm going to go ahead and pretend that the right for equality is in there anyway, because I'm going to interpret the right to dignity as if it includes the right to equality. And based on this right to equality, the court decided that these two laws, which these two big, political compromises, which allowed for the exemption of ultra-Orthodox men from military service, the court says these two laws violate the principle of equality, and therefore they are invalid. And I want you to understand how severe the situation is. These are duly enacted laws by the Knesset. They don't harm any specific rights. They don't harm any specific minority. They are historical political compromises at the heart of Israeli public debate and disputes. And this is where the court, having no sort of notion of justiciability or political question doctrine or anything like that, the court dives in, and based on a right which isn't even written in the law, based on a right which was explicitly deliberately not included in the law, the court then decides to strike down.
The only law I've heard from you is that you make her ready kill.
Huh?
Beg pardon, Mr. Cunningham?
What?
Oh, I'm sorry.
Oh, no.
James, you were saying that the discussion is not if the law is good or bad. The discussion is about the tools. Just a second. We'll reserve the question for the Q&A part. Okay.
Oh shit.
I cannot hear. Okay. Go ahead.
Right, we're going to continue. So we can definitely save some more questions for later. So again, this is a very, very strange situation. This is just one example. I'll give a few quick other examples, but the court has invalidated a host of laws. And again, often when you hear about people defend this situation, they say that it's about protecting minorities or protecting human rights. And so often we see something that has absolutely nothing to do with this. And I'll give you two quick more examples. Israel passed a law allowing the operation of private prisons, of private licensed prisons, meaning a prison which isn't directly administered by the government, but rather by a sort of licensed private entity, private corporation, et cetera. Now, again, whether you think this is a good or bad thing is irrelevant. There are many Western liberal democracies that have the system of licensed private prisons. This is not something which is unusual. And a legislature is, within its authority to decide that they want to do something like this. And the court struck that down. The court decided that prisoners have a right, because of the right to dignity, prisoners have a right to be administered by the state. Now, again, this is not a legal argument. There's nothing in the right to dignity that can impose on the legislature whether they want to have private prisons or not. Meaning this is pure policy making. This is pure imposition of values of priorities, of ultimately of ideology, of personal ideology by the judges on the legislature of their preferred policy. And this is where, I'm often reminded of Justice Antonin Scalia's quote, Justice Antonin Scalia, the famous conservative US Supreme Court justice, and where he said, on issues such as these, and I'm paraphrasing, this is a quote from one of his rulings, on issues such as these, the nine people on the court, the nine judges on the court don't know any better than 9 people selected at random from the Kansas City phone book. And his point here is whether you can have a private prison or not is not a legal question. There's nothing that judges know better than the electorate or than legislators about whether this is something which is valid from a perspective of dignity or democracy or liberty or whatever it is. This is a perfectly valid decision which can be made by a legislature. I'll make one last example just to sort of mix it up a little. Another law that was struck down by the court was a welfare-related law. There was an amendment to a welfare law that had to do with welfare benefits, and it changed the eligibility criteria for particular welfare benefits. And this
Having
law,
a car or not having a car, right?
Exactly. This was Bagatz Chasson, and this law said, I know this sounds, this might sound, and I think should sound to you fairly, arbitrary, and this is sort of totally, and this is sort of totally sort of kind of a random issue, but the law basically said that one of the eligibility criteria for a certain benefit was that you didn't own a car. If you owned a car, then you were not eligible to receive a certain benefit. Now, again, you can argue whether this is good or bad, or whether that made sense or didn't. I want to remind you, of course, this is also a financial decision, meaning, the government or the welfare state only has so much money. They decide how to allocate or how to give out those benefits. This is also a financial issue with financial ramifications. The court ultimately went ahead and said the right to dignity includes a right to basic minimal dignified living, something like that, to minimal dignified living. And therefore, this law, which made non-ownership of a car part of the eligibility criteria for a particular benefit, the court said that this law violates the right to dignity, and therefore they struck it down. And again, this is micromanagement of welfare policy. This has nothing to do with rights. It has nothing to do with minorities. This is pure judicial legislation. It's pure legislating from the bench, where the judges simply impose their own views based on a very wide or very flexible interpretation of what it says in these basic laws. So these are just a few examples of these laws which have been struck down. Just again to just kind of give you an image, but I do want to make a different point. We can disagree or agree about these laws, and that's perfectly fine, about the sort of interpretive method, about the basic laws, etc. But again, this brings us back to the fundamental problem. Look, I hear sometimes people say, well, the court has only struck down 22 laws since 1995, right? It isn't that terrible, or isn't that many. And that makes me think of a murder defendant sitting, at the witness stand and saying, guys, I only murdered 22 people. There's thousands of people that I haven't murdered. You should let me off the hook. I don't understand what the problem is. This is a very strange argument to me, because
even if it's only slapping on the face, not right. Murder, right? I've only slapped 22 people over the face, but when I go around, people know that I already hit 20 people. They don't mess with me.
Exactly. I've only attacked 22 people, and what's strange to me is that if under the current circumstances, when the court has no constitutional legitimacy to strike down legislation, even one is too many. So, and this idea that this is some kind of argument in defense of the court, that they've only struck down 22 laws and that somehow makes it okay, is insane. But the other point that I'm making here is that some of these laws that were struck down, the other question you need to be asking is which laws are these 22 laws? And some of these laws are the most important contentious issues in Israeli public life. And you can't just do away by saying that's, it's just another law that the court struck down. I gave an example of 2 laws which are fairly sort of arbitrary and not so important, like the private prisons or the welfare benefit criteria. But the question of ultra-Orthodox exemption from military service, that is one of the core issues in
Just
Israeli.
a second, I want to explain how it affects everybody here. Let's say, let's say we get to a compromise, okay, and that compromise is passed through Parliament. It has a huge effect on an issue. I'm not talking about the fact serving, not serving, even the economical life. You have to understand that as long as there is no exemption, there is a bit of a more motivation for them, not just not to serve in the military, but also not to join the economy. That they have to kind of stay in the yeshivas, which is great if they decide to do it. It's not so great if the state, through the elimination of the striking down of these compromises, forces them to do that as long as they don't serve. So there is a great economical effect on everyone here. And I'm all in favor of learning Torah, guys. You know, this is what I do for a living. I learn and I teach Torah, and I'm in favor of it. But the situation is causing people who don't want to sit and learn to sit and learn, because they are kind of incarcerated in the by these political situations, which are not, the court would not allow the parliament to reach a compromise. So it affects everybody here. It's a major policy issue.
Hey, baby. Hello.
Correct. Sorry, I put Mr. Cunningham on mute over there.
I did as well, the same time.
I think of course there's much to be said about that, and this goes into the substantive arguments in favor or against that particular policy. I think that's fine, but I'm deliberately
So Johnny, we've delved on what's not. Let's talk a little bit about the parts of the reform. What does it mean? You know, people talk about judicial overhaul, people talk about revolution, people talk about coup, all kinds of names, and the moment a person is talking and defining this process, at least in Hebrew, by the certain term they choose, you already get an idea what they think about it. So let's hear a little bit. I did a less than a minute video about the principles of the reform, but let's have it a little bit expanded. What is the reform about?
We went a tiny bit into the background, and I'll reiterate again what I said. I mean, there have been books and books written about the last 30 or 40 years of judicial activism and judicial overreach in Israel. Meaning, again, this, a few sentences of background for me is not really going to properly give you the full illustration of what's going on.
Sure, you can also view the conversation we had with Simcha Rotman, and we talk about some of these issues back then when his first book was published, or a few years ago.
I could recommend a few sources for reading or for further sort of learning. Maybe I'll send to Netanel a few links that he can send out to everybody that registered for the webinar, for the discussion here. Let's talk about the reform or the sort of suggested changes to the legal system in Israel. But for one moment before, I like to describe what the actual reforms do, but there's, I think, a broader point that really has to be made. And this is critical, I think, to any conversation about the reform. This relates to many other things that might come up. There are two conversations that can be had. One is about the specifics of the reform and the different measures which are being suggested and being discussed and put forward, et cetera. And that's a perfectly legitimate conversation, which we should have. That's conversation about pros and cons and what's better or worse, or et cetera. And that's excellent. But there's an entirely separate conversation or entirely separate argument, which goes along the lines of these reform suggestions, or the judicial reform is beyond the pale, or that they harm Israeli democracy, or that they turn Israel into a dictatorship, et cetera. And these arguments are completely outrageous and need to be rejected wholesale.
No.
Okay, sorry. Meaning there's two very, very different types of conversations here. What I want to make the point about democracy, which I'll make briefly, but we can get into this when we speak more specifically about the reforms themselves. Whatever you might think of the reforms, whether you think they're good or bad, there's three things that you need to keep in mind, and these are just examples of how I think outrageous it really is. What kind of how much of a twisted manipulation it is to describe these as harming democracy. First of all of the measures and the reforms make Israeli representative institutions stronger, meaning they grant more power to the legislature, more power to the Israeli public through the Israeli electorate through their representatives in the legislature. And this is critical to understand, because when people talk about other countries where you had democratic backsliding, or when people talk about Turkey or Viktor Orban's Hungary or whatever it is, without talking about those countries, in anywhere in the world, when we talk about democratic backsliding, you see the opposite. You see more power granted to the non-representative bodies, to the unelected bodies, whether it's the military, whether it's a specific political party, or whether it's various unelected bureaucracies. That's what we see around the world. In Israel, and this is a matter of fact, this isn't an issue of debate, every single one of the measures give more power to the electorate through the elected representatives. That's A. B, each of these measures brings Israel closer to what happens in the rest of the democratic world. We can discuss that in a moment, but each of these measures make Israel closer and more similar to other democracies in the world. Today is the anomaly. Today, Israel is in the unique and bizarre situation, which I've only slightly described. But again, these changes bring Israel closer to democratic countries in the world and around the world. And again, one can argue against these reforms. One can say, look, Israel is different. Israel needs different arrangements, which we shouldn't be like other democracies around the world. But that's a whole nother argument. That's an argument that has nothing to do with claiming that Israel is becoming less of a democracy because of these reforms. And the third and final point is this. In 1990, Israel was a democracy. In 1980, Israel was a democracy. Nobody argues that in 1980 or 1990, Israel was not a democracy. And these reforms bring Israel slightly closer to how it was in 1980 or 1990 from a regime perspective. And what I mean by that is that even if these reforms pass as they are today, the Knesset will be weaker, the parliament will be weaker, and the judiciary will be stronger than it was, or than they were in 1980 or 1990. So to claim that these reforms make Israel a dictatorship or somehow destroy Israel's democracy, one has to believe that in 1990 or 1980, Israel was not a democracy. And again, this is, I think, an obscene argument. And I think the best, and again, and now I'll move to the reforms themselves, but the best, just recently, I think a few days ago, Alan Dershowitz was on a panel, the well-known American constitutional attorney, Alan Dershowitz, and he was making exactly this point. He was saying, guys, this is not about democracy. Israel will completely remain in democracy if the reform were to pass as they are today, and he's against the reforms. He doesn't like the reforms as they are, and that's perfectly fine. But he says there's no merit to this argument that the reforms will somehow make Israel less democratic. If anything, they'll make them more democratic. And then, and we can go into this a little bit later, but he talks about how these protests have nothing to do with democracy. The protests against the reforms are the left protesting against the results of the elections, against the right who are in power. And again, that's perfectly fine and legitimate. They're within their rights to do that. But it has nothing to do with democracy. And if these exact same measures were being passed by a left-wing or a center-left government, then we wouldn't be seeing any of these objections at all, and nobody would be characterizing them as the end of democracy. Again, this isn't what I'm saying. This is what Alan Dershowitz said the other day, and he's against the reforms. So this is just to illustrate that there are two very, very different conversations. There's one about the reforms themselves, and the other is about this outrageous claim that somehow these reforms undermine Israeli democracy. So if this makes sense to you, Netanel, I'll sort of try and outline the major parts of the reform.
Yeah, let's talk about that, and then I'll try to make your life a little bit harder by kind of serving to try and deliver some of the points which I see with the people who are against the reform.
Absolutely. Okay, so I'm going to try and describe very, very briefly different elements of the reform. And I should say this is sort of stage A of the reform, meaning this is what the Minister of Justice, Yariv Levin, has posited as the first stage of the reform. There might be other elements of the reform along the way. But right now, the reform has four major elements. One has to do with the reasonableness doctrine, which I mentioned earlier. And there, the idea is to minimize somehow the reasonableness doctrine, either to get rid of it entirely or to limit it to certain circumstances and to make to have certain exceptions, meaning for example, that clearly political decisions by government ministers should not be subject to review by the reasonableness doctrine. So that's one area. The second area is judicial nominations or judicial appointments.
we can get into that into some detail. But today, judges are appointed in Israel by a 9-member committee. 3 of those members are presiding justices on the Supreme Court, meaning they are involved with selecting the people that actually join them on the court, which is already unusual from a comparative perspective, looking at other countries. And today, those 3 members, in fact, have a veto over who joins the Supreme Court. So,
a practical veto.
A practical veto, meaning the 3, because you need a 7-person majority in order to appoint people to the Supreme Court, then as long as those 3 judges vote as a block, and they always do and they always have, at least for the past 30 or 40 years, then they have the power to bar entrance to the court of anyone that they don't want. And this, in fact, has been used to great effect. I mean, this power has been used most notably in the example of Professor Neely Cohen and Professor Ruth Gavizon, both top-tier jurists who ultimately were barred from the court because the judges didn't like their jurisprudence and the judges didn't like their critique of the court. But again, that's already getting into some of the detail. The proposal, there are a few different proposals for change on the table, but the main gist of these proposals is removing the judicial veto, meaning not the judges not having veto power over who joins the court, and granting the main appointment power to the governing coalition, meaning if you've won the elections, if you have a governing coalition in the Knesset and the parliament, then you will have the power to appoint the judges. That's basically the gist of the change. Again, there are a few variations on this, so I'm not getting into the exact details. Then the third issue, which I'm really not going to get into at all, is the Attorney General and the powers of the Attorney General. I'm not getting into it just because it's such a complicated topic and it's so wide and it's so indefensible, meaning the situation in Israel is so bizarre and so unlike any democratic country in the world that it's almost, I mean, it's almost strange to talk about it. But the bottom line is that there's a very high-ranking civil servant in Israel called the Attorney General. It's actually, technically, it's called legal counsel to the government. And today, through a series of court rulings, this is not based on any kind of statutory law. The court has decided.
Brace yourself, guys, because it's really unbelievable.
The court has decided that the Attorney General's or that the legal counsel's office, that their opinions are binding on the government, meaning that they reflect the law as it is to the government, and the government has to comply with the legal opinions of the Attorney General. And I'm putting in parentheses for a second, think about what that means in the context of the reasonableness doctrine, or in the context of the way that I've described how the court interprets rights based on the basic laws, because what this means is that anything is a legal issue and anything can have a legal opinion, and any opinion of ideology or priorities or whatever, or values, ultimately has the guise of a legal opinion. And so this matters a lot. And
yeah, just a second. I want to stress that it is not just a matter of right and left here, because Prime Minister Rabin, for instance, who was the head of the Labor Party and a great leader of the Israeli left, okay, he was basically gagged by his advisor. His advisor went to the court, and Rabin said, I want to speak to the court as well. You know, listen to what I have to say. And the court told Rabin, you are the concurrent prime minister, but the real prime minister, the real opinion of the premiership is reflected by the legal advisor to the premiership. He said, but no, but I exist. I want to speak. And he sent a letter. He didn't arrive himself, but they wouldn't accept Prime Minister Yitzhak Rabin, the person's opinion, as the representing opinion of the prime minister, but rather the one of his legal advisor.
So this relates to another element of the powers of the legal counsel, which is that the legal counsel has been given effective monopoly of representation of the government in the court. And exactly as Netanel described, this includes arguing in court the exact opposite of the government's position in a manner where the government simply has no representation in court. So let's say if Netanel petitions against something that the government did and he says it's illegal, Netanel argues that it's illegal, and the government minister, the relevant government minister, let's say it's the Minister of Defense, says, I think my position is legal. This, here's my legal opinion, and I've read all the laws and I have different legal counsel. If the Attorney General, the legal counsel, agrees with Netanel and disagrees with the Minister of Defense, then he can simply say, Mr. Minister of Defense, I'm not going to represent you in court at all. And the judges are going to hear Netanel, a petitioner, and in the name of the Minister of Defense, they're going to hear the Attorney General, who agrees with Netanel, the petitioner, and this is going to be a one-sided conversation because everybody in theory agrees with Netanel, and the actual defense minister's view will never be heard in court. So this is another element of the powers of the Attorney General, and the aim of the reform is indeed to change that significantly and reduce the power.
And we've not even covered all of his powers. Listen, it's a Superman. It's a legal Superman. That's it.
Right.
He can fire the prime minister.
Right. So I'm saying to Netanel, this is really it's such a broad topic, and there's so much to discuss that really I'm just kind of giving up from the get-go. But that's yet another element. And then finally, the last element has to do with judicial review of legislation. I'm giving it as a sort of blanket. I'm giving it's really a category because there are a number of suggested changes here. But as a general category, it's about how and when the court can strike down legislation. And this includes a few proposed changes. One change is that the court can only strike down legislation with a larger bench, meaning with a larger quorum, a larger group. Today, the situation is that any bench, even 3 judges in the Supreme Court, can strike down legislation. So the proposals is a larger bench, whether it's all 15 judges or 12 judges, there's different sort of variations. The other is what majority is required. So not a regular majority, but rather a kind of special majority, let's say 12 out of 15 or 11 out of 13 or whatever it may end up being. Another element is limiting judicial review only to ordinary legislation. And this is a whole other topic, but in recent years, the court has reasoned and floated the idea that they can also strike down basic laws. And this is a very, very strange argument, but the argument, originally the argument of the court was that they could strike down regular laws because if they contradicted or violated basic laws. But now the court is arguing, no, it can actually strike down basic laws if they sufficiently contradict the fundamental values of the state of Israel as Jewish and democratic, etc. And this is, again, a very peculiar argument, which puts Israel as a complete outlier in the democratic world. There's no other country in the world that tries to claim this kind of, no other democratic, liberal, Western country in the world that tries to tries this kind of policy of striking down judicial amendments or constitutional amendments or constitutional clauses. We can get into that quite a bit. So these are all elements of the same sort of category. And then the final element of this is what some people call the override clause. I like calling it the insistence clause, which basically says that if the court does strike down a piece of legislation, then the Knesset, in some manner or other, gets to insist on leaving that law in place. And this is sort of similar to the notwithstanding clause in Canada or in Finland, but with some differences. And this is the sort of final part of that package, which says that the Knesset gets to insist on a law being valid, even if the court decides that it's invalid. And again, there's a lot of caveats here. There's a lot of nuances. I'm not getting into all the details. For example, with the override clause, one of the suggestions is that it has a limited amount of time to the effect of the override clause. Meaning, if you enact an override clause, you have to re-legislate it every 6 months or something like that. So there are all these different kinds of versions of the reform, but that's the broad description of what's happening right now, what's trying to be legislated, what they're trying to legislate right now.
Okay, so basically we've covered some of what's broken, so to speak, to make it simple. And we've talked about the basic tenets of the reform, which generally speaking, seek to shift some of the power that is vested today by, never mind how, at the currently with the judicial branch, to shift it back to the legislator. And I want to open, the next stage of our discussion, and I want to make one remark. I think that me personally, I've kind of shifted from that judicial nook and cranny discussion to the discussion of, okay, what do we do now politically in order to keep Israel, in a sane place before we get to a all-out constitutional crisis where let's say the new selection committee, nomination committee nominates a Supreme Court justice, and he comes to work, and the judiciary, there is the courts, how do you call them? Not court police, but kind of court. They have mishmar batei mishpat.
The judicial guard.
The judicial guard. Let's say they say, sorry, you cannot get into your office, and he calls the police before we get to these points, which can happen. It did happen in the history of other countries. So that's where I'm at, which is a different discussion now. But I want to ask you, I want to start the Q&A, and I'll ask the first question because I'm the most handsome guy here. Okay. Listen, people say that in Israel, we talk about the separation of the branches of government. Montesquieu spoke of three branches: the legislature, the executive, and the judiciary. In Israel, there is a very strong connection between the legislative branch and the executive branch. There is a committee of ministers, which is part of the government, part of the executive, which deals with legislation. So it would be like having a committee of judges dealing with legislation, theoretically speaking. And so they say Israel doesn't really have three branches. Israel has one political branch, which conflates or puts together the legislative and the executive in cahoots, in one bed. And on the other hand, you've got the judiciary. And so shifting the power from the judiciary to the political branch, to the one political branch, is not good for the future of Israel, because then the political branch, which is only one branch, would be unchecked or not with enough checks and balances. So this is a common, kind of the more sophisticated type of claim that you may hear from people who are, against the reform. What do you say to that? And then I'll open it to other people asking.
Okay, thank you, Netanel. So I will keep it short because I do want to hear people's questions, and if they want me to elaborate this more, then I'd be happy to. I think first of all, there's a broad point that has to be made, and we'll get into these in a second. But the broad point is this: even if you can point to various flaws in the Israeli system of government, and let's say that Israel lacks certain checks on the majoritarian institutions like the Knesset, et cetera. Let's say that there's too much overlap between the executive and the legislature in Israel. I am not familiar with any democracy in the world, and I'm not familiar with any doctrine in the world that justifies unelected bureaucrats stepping into that vacuum and imposing their worldview, their ideology, their values on the electorate as some kind of substitution for that. Meaning, I do believe that Israel should have a constitution. I think Israel's election system ought to be changed. I think that we need an upper house of representatives, a second, a bicameral legislature. I'm in favor of all these things. The fact that we should have those things, is something that you can't just magic out of thin air. You have to convince the population. You have to have, an intelligent public discussion about these things and bring them into being through discourse and legitimate democratic action. What you cannot do is use the lack of these things as an excuse for a worse form of tyranny. This cannot justify the kind of tyranny and judicial overreach that you have today. Judge Richard Posner is one of the most well-known American judges in the world and the most cited legal scholar of the 20th century. He described the Netanel Barak and what the Israeli Supreme Court did with Hamizrahi case. He described it as Napoleon taking the crown out of the Pope's hands, out of the bishop's hands, and putting it on his own head. And this is essentially, this kind of egregious judicial overreach, which imposes the views of a handful of unelected bureaucrats with no democratic legitimacy, with no constitution to legitimate them and to limit them. I'm not familiar with any model in the world which can justify this. Now, having said that, I think that these characterization of the flaws of Israeli, the Israeli system of government are simply not true, or they're grossly exaggerated. So for example, the overlap between the legislative and executive in Israel, that's called Westminster-style parliamentary democracy. The vast majority of democracies in the world have exactly that kind of overlap. And they're totally fine with it, meaning in most countries, in most democratic countries in the world, yes, the executive or the cabinet serves at the pleasure of the legislature or of parliament. And the parliament is the one that appoints the cabinet and the ministers. And indeed, there is great overlap, and whoever has the governing coalition in the parliament are the ones that appoint the executive, and there's an enormous amount of overlap. That's exactly what happens in most countries. From a comparative perspective, the government in Israel is weak and has less control of over the parliament compared to many other countries in the world. And there are many, many other reasons for this. It's because of the proportional representation system of elections that we have in Israel. It's because where minorities are represented and it's not a sort of regional first past the post system. It's because of the coalition government type of governing that we have in Israel. If you have other countries where you have one party, a single party that dominates the coalition, that's a situation in which the government has much more power, and you should be much more concerned about sort of monolithic action being taken by the governing coalition. That's not something that happens in Israel. Israel has never had a single party that controls the coalition. And these are just a few examples. And again, we can get into this, and this is getting into the weeds. That's fine. You can argue in favor of changes to these things, and I think that there are changes that are in order. But the fact that we want these changes, does not legitimate the tyranny of the minority, which is in many senses worse than the tyranny of the majority, right? The tyranny of the majority at least have the benefit of democratic legitimacy of being the majority. At least they were elected in some way. The tyranny of the majority is far more dangerous.
Minority.
Of the minority, sorry. The tyranny of the minority is far more dangerous and far worse. And in a practical sense, again, if we go back to real world, I know we're talking here sort of, high in the sky and et cetera.
Definitely. I want to, applaud everybody for staying,
right,
in tune.
Staying awake. It's pretty good.
Right.
Coming back to Israel, what we've seen is that everything that has been predicted, meaning the terrible consequences of these actions of the court, were predicted from day one by Israel's leading legal luminaries. They predicted by Professor Daniel Friedman, they were predicted by Professor Ruth Gavizon, and they were predicted by the retired Chief Justice of Israel, Moshe Landau, also while he was sitting on the bench as a judge and also later. He predicted the many terrible consequences of what would happen if the court took this power to itself. He predicted public trust in the court and in the legal system tanking. He predicted that people would want to change the way that of judicial nominations because they said, hang on, if judges are making these inherently political value-based decisions, then we want to say about how we nominate them. And we want the political branches to nominate these politicians, these judicial politicians. And he predicted that this would cause massive strain and massive omis. What's the word?
Overflow of the court.
Yes, too many cases on the court and a huge workload on the courts. All these things were predicted, and this is exactly what has happened. Because what happens when a court, without any legal basis, moves into these vacuums, and a court unilaterally says, nobody appointed me, but because of these perceived so-called flaws, I'm going to step in and I'm going to save all of you. That's no different from a general coming in with his army or with his platoon or with his regiment and saying, I'm going to save democracy from itself. I'm going to take over the Knesset for your own good. It's no different from the chief of police saying that. When the court does this, it lacks any kind of legitimacy. And what happens is that the public no longer trusts the court as a viable, legitimate actor. And one last remark about this. This is an argument that the left makes, not only the right in Israel. The most obvious example is Professor Meni Maudner, who's far on the left. He's sort of Meretz, Peace Now, breaking the silence, deep left guy. He was dean of the Tel Aviv Law School. He's one of Israel's most widely respected jurists. He says the political left in Israel has given up winning elections. It's given up persuading the people and getting their
majority
policy via the democratic and political process, and they've substituted that for working only for imposing their values through the legal system. And what he says about this is that this is cutting off the branch that they're sitting on because, according to Professor Meni Maudner, the role of the court is to protect minorities and it is to protect human rights. But it can only do that when the electorate accept that the court is merely enacting the law and not enacting its own policy preferences and is not a political actor which is serving and benefiting a certain particular ideological or political camp. And when the moment the court started doing that, the moment the court had started so clearly and explicitly benefiting a specific political camp and a specific ideological camp, then the very legitimacy of doing its most important role of protecting minorities and protecting rights is then undermined, because nobody is willing to accept that the court is acting as a neutral, impartial player who's enforcing rights and enforcing protection of minorities, and everybody perceives the court as being a political actor. And this is what Manny Maudner says, who's far on the left. So I just want to illustrate that this isn't sort of only a right-wing argument. Sorry, that was a very long answer to a short question.
Right. So guys, I'm opening it, and I would love for you to ask whatever you want, and even kind of if you have the way the reform is reflected in the media in your country, if you want to say what you've heard so far, a little bit about that, and then ask a question, that would be wonderful. I know they don't talk about it as much as we think people talk about it abroad, but if you have any point about that, you're more than welcome. You're more than welcome to raise your hand so I know you have a question. You click the raise hand button. You don't actually have to raise your hand. And go ahead, guys. So
I just want to say, I think it was Mr. Robert Miller. I saw you occasionally shaking your head or shifting, and maybe there was something, maybe there was a point that you wanted to raise or something you wanted to ask.
I didn't mean to be doing that, but I do have a question.
There you go.
Over here, we hear more about the Jewish settlements and the court, maybe, than other things. Would you mind talking about that a little bit?
Sure. Well, this is, I think, a really important example of everything we've been talking about, because over the years, the court has been extremely involved and influential with things that have to do with Jewish settlements in the West Bank and in Judea and Samaria. Yeah, and again, there are many examples. I mean, this goes from the reasonableness question, the reasonableness doctrine. It goes into the to striking down laws, specific laws, to ordering the various
the security fence,
changing the way that the security barrier, to changing the specific route of the security barrier. And I think we could go into the details, but I think there's the broader point that really has to be made here is twofold. One, in these examples and in others, the court has involved itself with questions which are purely political or ideological or policy questions. They cannot reasonably be construed to be legal questions. This is often the case, meaning sometimes there is a pure legal question, the court gets involved, and I'll talk about that in a second. But more often than not, these are questions of values. This is exactly what you have. This is exactly what you have the legislature. This is exactly what you have the legislature for. This is exactly what you have public debate in the legislature for, to decide these questions, not the court. But the other issue is that even if we were to agree with some of the results, let's say that there were some situations where we say, you know what, we want the court to be defending certain rights in these situations. We want the court to be limiting, the Israeli government from doing certain things, etc. The problem is that when the court imposes these views on the electorate or on the government, then the court loses a major part of its legitimacy, and these decisions themselves are perceived as illegitimate. Meaning, when the court imposes certain views, instead of these views being brought about by public discourse and debate, by public criticism, and eventually by actual policy by lawmakers or by the government, when the court imposes these views, then the policy itself that the court has created it continues having this sort of illegitimate core, and it will constantly be viewed by the public as something which lacks legitimacy, and that it both erodes faith and confidence in the court, but also erodes the actual faith in these decisions themselves, and they'll eventually be overturned. So I know that was a sort of very general answer. If you have this sort of more specific question you wanted about ask about settlements, then you're welcome to.
Just a second. I want to make a kind of a secondary effect that this has. Lawmakers know that the court is going to intervene. So lawmakers are not checking themselves and they don't bother reaching a compromise because they say, I can appeal to my base and I can legislate whatever I want, you know, without any compromises or without really thinking it through, because I know the court will intervene. And then it's not just affecting the legitimacy of the court, but it affects the reasonability of the lawmakers themselves, the way they conduct themselves.
Right. I think Netanel makes an excellent point. This is a point made by constitutional scholars all over the world in many contexts. So when the court steps into the political arena, as it has done in Israel on so many occasions, it has a deeply detrimental effect, a corrosive effect on political discourse and on public discourse. And lawmakers feel far less responsible for what they do, and they feel far less accountable for what they do when they have this backstop and they know the court is going to strike down what they do. So they know, meaning lawmakers know that they can do something which is outlandish or ridiculous or deeply harmful. And in regular circumstances, they might not have done it. But because they know now that the court is going to step in, or that the attorney general is going to step in, then they'll do it anyway, just to sort of score points for their base, or to sort of, in order for this sort of for a show of what they've been trying to do. And this has a deeply corrosive effect on the way that the political class conducts itself and their own policies, etc.
Betsy, I see your hand is up. Oh, unless, Robert, do you have a follow-up you wanted to ask?
No, I just wanted to thank you. I've got to leave, but I really enjoyed it.
Okay.
I have a question, and that is, how is the judicial reform going to get passed? And then what prevents the court from saying, oh, that's not legal, you can't do that, we're going to overturn it, and it all becomes a moot point?
It's an excellent, by the way, if before you answer, Johnny, it's an excellent question. I think it is a little bit beyond the legal discussion. It's already a purely political power discussion.
Well, Betsy, you really hit the nail on the head, because this is the question of questions, and it's a question that a lot of people are asking themselves right now in Israel. And like Netanel said, it's probably beyond the scope of everything we can discuss, but I'll try and answer in just a few lines. If that were to happen, and I think that's a terrible, terrible outcome, and I that would be something terrible for the court to do, and I hope that the court wouldn't entertain doing something so egregious. But if that were to happen, we would be in what people usually call a full-blown constitutional crisis. I argue that we've been in a constitutional crisis for 30 years. This is just the culmination of it, meaning we've been in a rolling constitutional crisis since the moment that the court invented that Israel has a constitution and started striking down laws based on that so-called invented constitution. Having said that, it's not impossible that the court may do this, and the court has been laying the groundwork to do this for quite a few years now. Since 2017, the court has been entertaining the thought that it can strike down basic laws, and today you have many academics, leading academics on the left, and judges as well, who have been sort of hinting in that direction, or even explicitly saying that the court will strike down these measures. Betsy, I think I think you really hit the nail on the head, because if you can imagine, one of the laws that are being passed is that the court cannot review the constitutionality of basic laws. And this itself is a basic law. So what happens when the court comes to review the constitutionality of a basic law, which says that the courts cannot review the constitutionality of basic laws? Like, how would that even work? But the answer to your question, I think, unfortunately, is this will depend. This will be a huge fight. It'll depend on public legitimacy of the different actors. To me, at least, this would be a constitutional crisis created by the court, caused by the court, and for which the court should and will be held responsible. Especially in the comparison that I think of is, if you can imagine, I said earlier, like a general coming in with a regiment, surrounding the Knesset, and taken over the Knesset and the cabinet at gunpoint. And if you can then imagine someone trying to wrest control of the Knesset from this general, and then the general crying out, you're going to cause a constitutional crisis, right? And that's how absurd I think the situation is now, because I think the court is causing this constitutional crisis, and I very much hope that the court would not do such a thing. And if they were to do it, then it's anyone's guess how it would eventually play out. One point that I want to make there, one last point, is this: the desire for reform is a grassroots desire, which is shared by an enormous part of the population and of the electorate. This isn't a power grab by a bunch of politicians who are trying to gain some momentary benefit. And this is critical to understand, because even if the court would do that, eventually this will play out in the way of constitutional change by the electorate. I think there's no stopping the electorate who ultimately want to see this change. And it's just a question of how much scorched earth there's going to be on the way, and how many, consecutive crises we're going to see caused by the court or other actors on the way there. I see we have a few hands raised. Sorry, go ahead.
I just want to follow up quickly, and it was the media and the way they are portraying the situation and the protests and the influence coming in even from American politicians over the situation. It is a hard battle to fight. I know the current government in power was elected by a majority of people, and I wonder how you get, the majority tends to be quieter than the protesters right now.
Okay, I want to answer your question, but I do want to let I see there are 3 hands raised.
Right.
Okay.
If it makes sense,
Frank, your hand was there long, so go ahead.
And I'll try and answer. Netanel, why don't we hear all 3 questions, and then I'll try and see what I can answer.
Okay, sure. Let's go like that. Frank, go ahead.
Go ahead.
Yeah, as concisely, and thank you for being here with us today.
Thank you, Frank.
As concisely as I can, I think about where is Torah in all of this, Torah min hashemayim, and I think about it in terms of Deuteronomy chapter 4, where,
That's the laws now.
yeah. So, I understand the disputes that are going on, in our country. We, as Betsy has said, we have a lot of squabbling going on all the time. And it's like children in the playground.
Right.
And without some higher authority or higher power that you trust.
Right.
So that
how can you come to any conclusion that's not actually pragmatic?
Right,
okay.
I'll try to address that. Go ahead. James, you had a question?
James?
You kept saying Constitution. Israel doesn't have a constitution.
Right.
So what do you mean by breaking it?
Right.
It's unconstitutional.
Right. I'll address that very briefly, but you're absolutely right, James. And Jerome?
Mine is, what would Moses do?
Yeah. He would rule.
Yeah, but my question is that it's hard for anyone to give up power. And that's one of the most difficult things to do, whether you're the legislature, have tyranny, the executive tyranny, or whether it's judicial tyranny. No one wants to give up power. And so no matter what happens, when you make these changes, there's still an underlying bureaucracy that you have to then work with. Is there going to be any kind of reform in limiting the growth of the bureaucracy?
That's also a wonderful question. Okay, so I'll try and answer as briefly as possible all these questions. For Betsy, you asked about the protests and the sort of silent majority, and this ties in, I think, also to Jerome's question about whoever has power not wanting to let it go, and these two are deeply related. So the left are first of all very well organized and very well mobilized, and they're doing a great job in the way that the right, I think, in Israel could only envy. Meaning the political left in Israel are certainly very effective in the way that they mobilize and protest, and the way that their messaging is very sort of on point and concise in there. I think they deserve that credit of being extremely effective in the way that they sort of vocalize their views. But I believe, this is my personal opinion, the correct way to see this is just that. It's just the political left protesting against, not only against the right-wing government and the sort of government, the results of the election, but more importantly, this is political left protecting a major source and focal point of their power, meaning unlike other things that they've protested in the past, the political left has been the main beneficiary of the court's encroachment, of the court's tyranny, of the court's power grabs. And in that sense, the political left certainly have a real, true interest in stopping or in somehow eliminating these proposed changes. And they're doing everything in their power to stop it. So this relates to the protests, it relates to the media. And Betsy asked, what is the silent majority going to do? Well, I hope they do a better job of messaging and of getting their own message across. I think hopefully eventually the politics will win out, meaning eventually, we have a legislature, we have elections. This is exactly what they're for. And if for any reason the reform is frustrated at this point, then it'll just wait till the next election or to the one after that, meaning eventually the people will win out. I'm very much hoping. Jerome, you spoke about the bureaucracy, and I think the short answer is, at least on some level, yes, there are some efforts to sort of minimize the ability of the bureaucracy to sort of have their way or to frustrate these efforts. And on the other hand, I want to say, look, a very large, we talk about the silent majority. There's also the silent bureaucracy, meaning there are a lot of people in the Israeli bureaucratic establishment who identify with the reforms, who want to see them happen, who would be in favor of being part of the bureaucracy after the reforms. And they're people who I think will have more of a voice and ultimately would probably also be promoted more or whatever it is, or their career will be more advanced after the reform. So and I'm going to give some credit. Ultimately, I believe that people in the bureaucracy are well-meaning patriots, and ultimately they want to serve the state. And if, some of them, if they feel that they can't serve their role anymore, they'll resign. And others will sort of, a different sense of resign. They will be resigned to this reform being the will of the people and being enacted. That's what I'm giving some credit to these people in the bureaucracy, and I believe that that's what they will do in most of the cases. James asked totally correctly, how am I using the term constitutional when Israel doesn't have a constitution? The short answer is that, the UK is a constitutional monarchy, right? Meaning we use the term constitution not only to mean that particular document like the US Constitution or like the Canadian Charter or like, I don't know, the Norwegian Constitution or whatever it is. We use the term also to mean sort of the fundamental arrangements of a particular regime. So I totally agree with you, James. Israel does not have a constitution, and in many contexts, it wouldn't be correct to use the term constitutional for Israel. I totally agree with you.
Right. When this started, right, someone came to me like in the very beginning of it. What do you say about the constitutional revolution? I said to him, everything that starts with constitutional, you should always be suspicious of.
Right. Absolutely. No, So it comes down to being a terminological question, but
no, it's complicated because again, those basic laws were supposed to be the draft of a future constitution. So, yeah,
I'll say differently that I think it's very understandable and even correct for people in countries with a constitution, or for people who know what an ordinary constitution is. It's perfectly legitimate, and they'd be justified in asking, how the heck are we talking about constitutional law in Israel when Israel lacks anything approaching what is commonly understood to be a constitution? Mm-hmm. That's absolutely correct. Finally, Frank, you had a question about Torah or God or a higher power. And, my only remark to that would be, the beautiful part of democracy is that the whole idea is that the people in the electorate are sort of constantly jostling about issues, including that issue, right? Sort of, what is the role of religion in society? What is the role of God in society, whatever it is? And that's sort of a constant part of what democracy is about, that you have these sort of different parts of the electorate arguing about. What's undemocratic is when the court steps in and imposes its particular view on the electorate. So when the court comes along and says, I will tell you what the final result should be, I will tell you what the correct balance is between religion and state, I will tell you what is the correct, measure of involvement of God or Torah or whatever it is in public life or private life or whatever it is. And that's the problem that we have in Israel, meaning, I think Democratic electorate is entitled to make whatever decision it does as long as it's through the electoral political process. That's what it's there for, to overcome differences and to find compromise. And the court completely undermines that when it imposes its views and its desired results on the electorate. Okay, we really have to finish, and I have to go. I have a hard stop. Jerome, maybe one last question or remark.
Your hand is still up, Jerome. Jerry?
Jerome,
Okay.
you're
Yeah, I
muted.
can unmute. Yeah, I wanted to know how I can support this nonprofit. I'd like to not just raise my hand, but raise my credit card.
Okay, first of all, that's very kind of you, and I will send Netanel some details which he can distribute to the group if they're interested. I would like to reiterate again that I've only been representing my own views, my personal views as an Israeli expert, and
But it should be a personal contribution, not to the NGO. No, I'm just kidding. I'm just kidding.
I'm not accepting any personal contribution. And of course, anyone that would like to contribute to our organization is welcome to. It's a 501(c) organization and tax deductible, etc. And I'm happy to distribute that information. But I think that people that agreed with what I said today will certainly also identify with what the organization that I run is doing. So I think that those are certainly consistent in that sense. But it's important for me to make that distinction. And then Netanel, if there's anything else you want to say, I'm done.
Yeah, I want to say that, yeah, I started with it. I think that the discussion at the moment, first of all, it was, thank you very much for coming. It was very eloquently put. Even when we said the same thing, you said it much better. So, thank you for coming. That's one thing. Secondly, I think that we are at that point relating to Betsy's question of what's the way to proceed in a way that will not ruin our country and yet will be able to take it to a better place as we understand, as the majority understands that better place to be. So that's like the main question. Maybe I should have a marriage counselor come next, not a legal expert, right?
Need a mediator for the next.
A mediator or a marriage, yeah, something
If
like
you
that.
look, the way forward, whatever it is, has to consider or has to reject the argument that this is the end of democracy.
Oh, that's for sure. That's for sure.
And then because all the outlandish, outrageous actions are ultimately legitimized by this sort of weaponized argument that this is the end of democracy, and everything can then be justified as if this were the end of democracy. And that's how the left
in Judaism, it's called She'at Hashmad. Judaism has three tenets you don't break under any circumstances. So, but all of the other tenets, if they tell you, I'll kill you if you don't defile the Shabbat, you do whatever they tell you to do on Shabbat. You can even eat pork if you're threatened. But
this is the argument that these are extreme circumstances that justify anything, and that argument has to be wholeheartedly and wholesalely rejected. And then we can actually start looking forward at some kind of compromise or solution or accommodation or whatever it is. I really do have to get going, but thank you again. Thank you very much.
Thank you. And I want to thank everybody for coming and listening. I don't know if I would sit to listen about an hour and a half about Namibian constitutional crisis or South African for that matter, or whoever. So thank you for giving our small state that so much attention and helping us and thinking of us. And we need your support in so many ways. So thank you very much for coming.
Thank you all.
Thank you very much, Johnny. Thank you guys again for coming.
Netanel, tell me again that one thing that you cannot do, you will not violate.
Oh, so there are three things you cannot do, even if you're threatened with your life. You cannot kill someone. You cannot commit ancestry or adultery. and you cannot worship foreign gods. Okay, these three tenets you cannot do even when threatened with your life. However, in extreme circumstances, when the whole people is threatened, when the whole religion, the faith is threatened, you say this is the time of destruction, or literally, or maybe the translation is not the best. But then you have to insist even on the color of the shoelaces, the Talmud says. Okay, so I think the political left in Israel feels it's that kind of a time for them. And so this is why they insist on even the color of the shoelaces legally.
Got it.
That's the point. Guys, thank you very
Thank
much.
All right.
And I'm privileged to have such a smart and open and interested students from all over.
Thank you. Thank you.
Right. No, yeah, Annette, I was just making, without any, without any kind of disrespect to Namibia or South Africa, I was just making a point. Bye-bye, guys.
Bye-bye.
Thank you, Netanel. Wonderful.
Thank you. Bye-bye.
Shalom, shalom.
Shalom, guys.